Welcome to episode 12 on the law report. This is part 2 in the mini series Defenses in Criminal Law. Today, I would like to deal with the defense of duress and necessity and a few other defenses that will follow in this presentation. But for the usual disclaimer, this is not legal advice. It should not be construed as legal advice. And for legal advice, please contact a competent attorney of your choice. As you may remember, in an earlier episode, we dealt with the issue or the defense of necessity. And we posed the question if it exists in English law. And there were a number of instances where the defense was raised and it was rejected, but we pointed out in medical cases the defense was upheld on numerous occasions. Now, the defense of necessity and duress often intertwine. And in recent cases and duress of circumstances, it appears to be an overlap with the defense of necessity. And very often, both terms are used interchangeably as simply being different labels for essentially the same thing. The defense of duress arises where a defendant is threatened by another with death or serious injury if he or she does not commit a crime. In the case of DPP and Lynch of 1975 House of Lords case, Lord Morris in that case said the following: the law must, I think, have a common sense view. If someone is forced at gunpoint either to be inactive or to do something positive, must the law not remember that the instincts and perhaps the duty of self-preservation is powerful and natural? The defense of necessity potentially arises where a defendant claims that he or she had to commit a crime because there were no other alternative and the crime was committed to prevent some greater evil. For example, and we spoke about this case when we did the episode on necessity as a defense in English law. In the case of the Queen and Dudley and Stevens of 1884, the defense of necessity was raised and soundly rejected. And this case is a very interesting case that I will rehearse the facts very briefly. The two defendants and another man and a cabin boy became shipwrecked, and they were stranded for about 18 days when they ran out of food and water. The defendants agreed to just charge to see which one of them would be killed so that the other could eat him. The third man did not agree and the cabin boy was too weak to take part in any decision. As the third man had not agreed, the defendants decided that it would be better to kill the cabin boy, as he was close to death and he had no family. Dudley and Stevens cut the cabin boy's throat and ate him, and they returned to England. Dudley and Stevens were charged with the boy's murder. It was held that the defense of necessity was not available to the defendants, and they were convicted and sentenced to prison. We now turn to the defense of insanity. The defense is available in both the Magistrates' Court and the Supreme Court. And this defense may negate the intent of any crime, although it pertains only to those crimes that have an intent element, especially the element of specific intent. It has been raised in other cases. The burden of proof rests on the defendant to show, on the balance of probabilities, that he was insane at the time of the act, and it is for the judge to determine whether a defense raised is in fact one of insanity. And this may give rise to issues of whether the defendant is fit to plead to the charge, whether he understands the proceedings, and whether he could withstand the rigors of the criminal trial. A person in law is considered to be able to avail themselves of the defense if they suffer from a disease of the mind, which must cause a defect of reason, so that the defendant either did not know the nature and quality of the act, or did not know that what they were doing was wrong. So in other words, the defendant must have lost their powers of reasoning, being absent-minded or confused enough to be unable to reason correctly is not sufficient, and this was determined in the case of the Queen and Clark of 1972. At the heart of the rationale for the insanity defense is the principle that criminal punishment should only be imposed upon those who are responsible for their conduct, and that is persons who intended to do what they did, and when they committed the act, that they knew what they were doing was wrong and they had the specific intent. They were of sound mind. What constituted insanity was debated until resolved by the rule in M. Nathan's case. In that case, the defendant had shot and killed the secretary to a politician. That politician was Sir Robert Peel, and the defendant had intended to kill Sir Robert. He was tried for murder. He was acquitted on the grounds of insanity, and there was public uproar following the verdict. The issue of insanity was then debated in the House of Lords as to the law governing the defense of insanity. 5 questions were put to the judges of the day, and the answers to 2 of those questions form the basis of the M. Nathan rules as we know it today. The key principle that came out from these rules is that in order to establish a defense on the grounds of insanity, it must be clearly proved that at the time of committing the act, the party accused was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he or she was doing. Or if he did know the nature and quality of the act, he did not know what he was doing was wrong. The next defense I would like to discuss is that of intoxication. A significant proportion of criminal offenses are committed by persons under the influence of alcohol or drugs. The law is reluctant to allow drunken persons to escape criminal liability, and therefore draws a distinction between voluntary and involuntary intoxication. The general rule is that drunkenness is only a complete defense in the latter situation. So it's only a complete defense in cases of involuntary intoxication. Voluntary drunkenness is normally no defense, but in certain circumstances, it is allowed to operate as a partial excuse, reducing the level of criminal liability and punishment. This defense was at the heart of the case of the Queen and Kingston of 1995, a case that was ultimately determined by the House of Lords. The appellant in this case, his drink was laced with drugs, and he indecently assaulted a 15-year-old boy. He was convicted at first instance. The judge, having directed the jury that they should not convict if they found that he was so affected by the drugs that he lacked the intent, but to convict if he had the intent. The Court of Appeal upheld his appeal on the basis that the operative fault was not the defendant's. The Crown appealed to the House of Lords. The appeal was allowed. Lord Mustill, in his judgment inter alia, said, "The ends of justice makes no demands for the interplay between the wrong done to the victim, the individual characters and frailties of the defendant, and the pharmacological effects of whatever drug may be potentially involved." He said that this can far better be recognized by a tailored choice from the range of sentences available to the judge than by a single yea and nay jury direction. I considered, he said, that both the ruling and the direction of the judge was correct. And so, in that case, the defense failed, even though it was one of involuntary intoxication. Next, we'll discuss the defense of Atomatism. This defense entitles the defendant to a complete acquittal. However, the law has rigorously circumscribed the parameters of the defense, fearing that it may lead to too many acquittals. Generally, at common law, a voluntary act is required to establish the actus reus of a crime. The defendant should also be conscious of their acts so that mens rea can be established. If a defendant, however, can show that they committed a crime as a result of an involuntary act, they may be able to plead the defense of Automatism. In the case of Bratty and the Attorney General of Northern Ireland of 1963, Lord Denning described an act as involuntary when it is done by the muscles without any control of the mind, or by a person who is not conscious of what he is doing. The defense of Atomatism is limited in the following circumstances: where Automatism is caused by a disease of the mind, where it is caused by self-induced intoxication, where it is caused by a self-induced incapacity other than intoxication due to drugs or drink, etc., failure to eat while taking insulin, or where there is only a partial destruction of voluntary control on the defendant's part. And this is divided into non-insane and insane Automatism. This will require an episode by itself, and so I do not wish to go into any details into this defense. Suffice to say that non-insane Automatism is distinguished from insane Automatism. Both involve an involuntary act. However, with insane Automatism, the voluntary action must have been caused by an internal factor. And for non-insane Automatism, in order for it to be proven, the involuntary action must have been caused by an external factor. I would like to discuss the defenses of superior orders and impossibility. The defense of superior orders has constantly been raised and rejected by the courts. This defense is raised where a superior officer in the military or the police force or some quasi-military organization may give orders to a subordinate or junior officer to carry out an act that may lead to some illegality or some breaking of the law. And then the junior officer would seek to rely on the defense of superior orders. Well, the orders to do what I did came from higher up. The code has repeatedly rejected this defense. In the case of the Queen and Abbot of 1976, Lord Salmon said that the idea of such a defense has always been universally rejected. In the case of Regina or the Queen and Clegg of 1995, the House of Lords held that a soldier would not be entitled to be acquitted by virtue of superior orders, as, wait for it, no such defense is known to English law. In a case out of Hong Kong, the case of Yip Cho Chong of 1987, it was held that a person who acted as an undercover agent to break a drug trafficking ring in Hong Kong could be guilty of conspiring to traffic in dangerous drugs. The test is one of palpable illegality, where the order is so manifestly and palpably illegal that a reasonable man in the circumstances of a soldier would know them to be. So, as an example, if a superior officer were to give a junior officer an order to kill unarmed civilian, defenseless women and children, non-combatants, or to burn a village, clearly that would be a crime, and a crime against humanity. And if the junior officer were to blindly follow those orders, he cannot rely on the defense that those orders came from superior officer. He will be liable and responsible for his own actions and any criminal liability and sanctions that follow. And as a reasonably an astute individual, or as a reasonably astute individual, he ought to know that the order that he was given was palpably illegal and manifestly wrong, and should, in good conscience, resist it. And so the courts have said that it is unconscionable to rely on the defense in such circumstances. The defense of impossibility. This defense is occasionally used when a defendant is accused of a criminal attempt that failed only because the crime was factually or legally impossible to commit. Even if it may not be possible to commit the full offense because the factual basis is not present, if the facts had been as the defendant believed them to be, they can still be charged for attempting to commit the offense in question. And this principle emanated from the case of Shipori of 1986. So once a person did what is more than merely preparatory in the commission of the offense, even if the offense was impossible to commit, they could still be charged for and convicted for attempting to commit the offense. Here is where I will leave it for this episode. The defenses that I've discussed in episode 1 and 2 of criminal defenses, or of defenses in criminal law, is by no way exhaustive, as defense could arise and the facts and circumstances of the case or defenses could arise under statute. And a statutory defense is a defense that is enacted within the statute itself, and if that evidential threshold is overcome by the defendant, then he would discharge the burden under the statute and should be able to, or should be entitled to an acquittal. In another episode, a subsequent episode, I will deal with special defenses in criminal law. I think this deserves an episode by itself. And so I thank you for listening. I thank you for watching. And if you like what I'm doing, please leave a comment. Thank you.